You mean well, the personal costs and me as a human being being treated like that? You mean that, Mr. T?
Yes, both PP.
Yes. Well, I said well to one of the journalists of Citizen. I think you've seen the article because I was appearing for this perjury charge as well, which is being the complaint lodged by, or the case opened by this advocate Hoffman, and that I must face perjury for the CX matter. And I think those who are listening directly to the hearings, the evidence, or the witnesses, I think you've seen for yourself, or you've heard for yourself what transpired. So now, being punished by the Constitutional Court, I think you remember that first judgment by Justices Kampempe and Theron and the others, and I had to be assisted by Democracy in Action, who also at the later stage were dealt with because possibly they shouldn't have assisted me. And I mean, being an NGO as well, assisting any other person whose rights have been violated. So I think I said possibly I'm not a human being, or I shouldn't be treated as a human being, or as well, because how on earth am I expected to pay personal costs from my pocket? The recent one was the worst because I mean I'm said to be abusing the court process. I don't know how, but that's the story of my life, and I think it's very concerning. In this democracy, we find ourselves having to deal with issues like this, and I think it's a concern then whoever is going to be the public protector or Chapter 9 institutions, because this doesn't only apply to me, to even all other constitutional institutions, because it's one thing we used to discuss with the institutions supporting democracy, that it might be me today, but tomorrow it might be the Auditor General, it might be the Public Service Commission chairperson. So, well, for now, yes, the focus is on me. Yeah, so I think that's what I would say, Mr. T.
No, thanks, PP. No, we, and you know what, PP, I talk to a lot of people who do appreciate you and see what you are going through. And I mean, we all see that, this protection of our democracy and our institutions is definitely coming at a price, PP. But I'm sure that, however painful it might be at the moment, it will pay off in the long run. You are fighting a
Mm,
big fight here. And I think this is a lot more about our nation than it is about these self-interested groups. And perhaps Advocate Mpofu can touch on this. Now what bothers me is, man, Hopaka PP, there's this sort of like a triangular fight against the PP, where you see the Concord and the president at the top. Bottom left, you'll
mm.
see the PP's office under the current occupancy, and then on the right, of course, get the DA. I mean, what's going on there? Advocate both.
Hey, Mr. T, how are you?
Good leadership.
Yeah, no, we're fine. Thank you. Good evening, everyone. Good evening, PP. Yeah, we're in trouble. I think that's really a summary of what's happening in this country. As the PP said, yeah, I can't get too deep into the merits of the cases, particularly those that are still going to go to court. But I think what I can do is just to talk broadly on some of the issues, particularly the misinformation on the legal implications of the judgment and that kind of thing, because those are broad general issues we should apply to any other judgment. And I think cases like this are quite unique and not your everyday kind of stuff. So they also provide an opportunity, I think, for us to educate each other about our constitution, so that when a similar thing happens again, we have a broader understanding. Because even for us as lawyers, the Constitution is something relatively new. As a democracy, was still a baby of 28, 29 years old. So there's a lot. There's still the Constitution is still going to be developed over the next 100 years or so, and start to take shape. And those of us who live in this era are actually the pathfinders and those who will breathe life into the Constitution. I think before we even get to those legal issues, Mr. T, I want to talk about some of the broader issues that you have raised. One of my big bugbears about all this is the lack of support, visible support, I think, by us as Black people when one of our own is under such serious attack. And I think we should really never tire to thank you, Mr. T, for having a platform like this. You might think that it's a small thing, but it's a big, 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 big contribution to where we want to be. Because until we create our own platforms for discussion and even difference and debate, it's until we do that, then we're going to be victims of narrative journalism, which is really what is happening here. Even this issue about so-called confirmation of the judgment in the Constitutional Court is nothing else but a narrative that was created, as somebody mentioned, within an hour of the judgment coming out. The narrative was created, and it's shocking how before we even had, when the judgment came, we were in a hearing, as you might know. Before we even finished there, that narrative was all over. I'm sure not only in South Africa, but everywhere else. That's how well coordinated these people are. And the narrative was false, completely false. But it was created just to create doubt, because I'm sure everyone understood how there would be this jubilation and excitement, which might carry, the momentum against those who have not succeeded in that case. So it had to be arrested by just planting something, just crying wolf. And then all of us were busy parroting this nonsense. No, the judgment still has to be confirmed and what have you. Even when the people who had originated the thing had already abandoned it because they knew it was nonsense. I mean, we dealt with that, quite frankly. If you saw how we dealt, we got that letter. We were still busy with something else, and we just scribbled a response and told those people that they must go and read the law properly. And they ran away with the tails between their legs. And as the PP says, then they decided on a plan B, which was the so-called appeal, because they realized that that first scarecrow tactic didn't work. We just told them where to get off. But after they had run away, until now, people are still debating the thing about the confirmation. There's no such thing as a need for confirmation of that judgment. And I think the letter that we wrote from Sianeho, that we wrote back to the DA, I hope that it is out there now. If people can look at it, we've put there 3 reasons why that argument is nonsensical. And as I say, its originators have long accepted that it is nonsensical. For some of the reasons that the PP has mentioned, so I don't need to repeat that. Because the point I'm making really is more about this narrative journalism. We've seen that playing its course in the inquiry as well. There are people whose business it is to just push a particular narrative, and with a few exceptions like this platform, there's nobody who's even trying to give a counter narrative. I remember I think that 2 or 3 days ago in the inquiry, we had evidence about the so-called legal spend, which was packaged in such a way that, again, to create sensationalism. Something like, since 2015 or 2016, the Office of the Public Protector has spent 145 million rand on legal fees. And then the following, within an hour, it's all over the media. The public protector has spent 145 million rand on legal fees. Nobody says now it's over a period of 6 years or whatever, because if you do that, then it's going to be clear that you are talking about a budget of maybe averagely 20 million per year. And given the size of the organization, I mean, just to give you perspective, the police spend about 300 million per year on legal fees, and the departments like Home Affairs maybe 70-80 million, averagely 50 to 70 million per annum. So you can't, when people want you to be shocked, they just create shock, and you also get shocked because they want. Now you're shocked in the air. You don't even know why you're shocked, because you're told about this figure, but you can't put it in perspective. You can't compare it to anything. You can't compare it to the size of the organization, but you are told that this is not a good thing, and therefore it's not a good thing. Now, incidentally, on that day, it was the day that we revealed at the commission that the public protector had just achieved her third successive clean audit. And the peddlers of the narrative, not even one of them reported on that. So literally on the same day, let's assume both stories are newsworthy. There's a clean audit, and then there's the quote-unquote overspending. But people are unashamedly to just write about the one that they want to write about, and that's it. And they're supposed to be the neutral informers of the public. So that's something that I think we must watch out for. Now, coming back to the judgment itself, the PP has already indicated what has happened now. I can just give you a bite of the papers. Last night we did not sleep. Once the DA sent us their papers in the evening, and I think that it was clear what the intention was. It was to prevent the PP going back to her office. And in our view, that's just tantamount to the DA was basically issuing another suspension letter by doing that, because that's really what it was meant to do. It was taking over the work of the president, or the power of the president, by using the legal system in order to reinstate the suspension letter effectively. And that is what we're going to court in respect of on Tuesday. We just served the papers 2-3 hours ago, and we're hoping that it's going to be quite a challenge to reassemble the full court of 3 judges within such a short space of time. But we're hoping that if it's not Tuesday, it will be soon thereafter. And that's where the real issue is, not this nonsense about confirmation. It's you see, what they were doing is, in our law, if you lodge an application for leave to appeal, then it automatically suspends the judgment. It doesn't matter what the merits or demerits of that application is. Some people might remember I argued this issue a few months ago, before the Western Cape Court, to explain the impact of an application for leave to appeal. And so, but nobody, I mean, it's nobody, they have 15 days within which to appeal. So the mere fact that they did it within hours is instead of exercising their right within the 15 days that they are allowed to do, should make it clear what the real intention was, which was just to ensure that the public protector doesn't go to her office. So that's going to be quite an interesting debate. Those who are able to follow it, I don't know if it will be covered. Please do listen carefully, because it will reveal what we see as a very well coordinated campaign to make sure that the public protector doesn't go back to her office pending this so-called appeal. I think the final issue about that is that it's quite a risky strategy that the DA has played, because by doing this, they've forced us to take the stance that we've taken. And if we succeed in this stance, then they would have shot themselves in the foot, because then there'll be a court order that effectively says she cannot be touched until the end of their own appeal. And so where they think they are resuspending her, they might actually be giving her immunity from any further such action. I think I'll leave it there, Mr. T, and so that I can take specific questions, or maybe whoever wants to ask the PPA or myself about some of the specifics. Thank you.
Thanks, Advocate Mpofu. Much appreciated. Yeah, I mean, from me, I will have two things, Advocate. One is the role of the acting PP in all of this. I mean, uh, in fact, why is she writing, PP this letter that, PP cannot return? Shouldn't she be engaging the Western Cape High Court on this? And my second point, and you kind of touched on this, but it bothers me. It really bothers me that, black law firms in South Africa are treated this way. We have great legal minds. I mean, Advocate Mpofu here just won a huge decision here, and there are people crying about how much money it costs. You never hear them talking about how much money the government pays to white law firms. And by the
Mm.
way, that's something that's happened for centuries. They've amassed billions in legal,
Yeah.
fees from government. But yeah, please, Advocate, if you can touch on those two things there.
Yeah. Okay. Now, the first one, I'd rather not talk about it, the thing of the acting public protector. So, except maybe to say that it's a very interesting what will happen, as I say, after the Tuesday case, and also some of the implications of the judgment. It goes back to this issue about the so-called confirmation. The clearest sign that there's no confirmation issue here is the language that was used by the judges in fashioning their orders. There are two separate orders, three orders that have been made in our favor. The first one was about the issue of the acting public protector trying to withdraw the case. That obviously failed because we have a judgment now. The second is about the declaration of invalidity. Now, there is one of the first sign that there's no confirmation issue is the fact that that order say it is the decision of the president that is set aside, or rather that is declared to be invalid. And the section 172.2a talks about the conduct. Now, in those who are legally trained who are listening here will know that a decision can be reviewed and conduct can be declared invalid. So conduct and a decision are not the same thing. In normal language, they may look like the same thing, but law is quite a specific thing. So that firstly shows you that that section that they want to invoke doesn't apply. But the main issue is the next order, the last order in our favor, which says that the suspension, I'm just paraphrasing it now, the suspension is set aside with effect from the date of this judgment, which means with effect from yesterday. So this whole thing about suspension means that what it means in normal language is that a judgment which is given, let's say, for example, which invalidates a statute, is not effective until it is confirmed by the Constitutional Court. So these judges have already answered that thing by saying it's effective. Their judgment is effective with effect from yesterday. So that's quite a clear issue. The thing about the acting public protector, Mr. T, is that it's not even legally speaking. Once the public protector was reinstated yesterday, which she was, then the status quo before she was suspended returns. So, as to whether when the DA then put their application, that also automatically means that the acting public protector also becomes the acting public protector again. That's an interesting legal question. I don't have an immediate answer. But it's not such a clear-cut thing as I think she thinks it is, which is that because the judgment is suspended, therefore she automatically becomes reinstated into the position. Because the reality is that until the DA's application for leave to appeal was lodged, the public protector was back in office. The mere fact that she wasn't there physically is just a coincidence. Theoretically, at 3 o'clock or whenever the judgment was given, she could have just gone to the office. And then when the DA files its application, then the judgment would have been suspended. Yeah. So, I think that's all I can say about that for various diplomatic reasons. Yeah. But I think there'll come a time where we have to say these things as they are. I don't know if I've covered your second question properly, Mr. T, but the first one, as you can see, I'm trying to avoid your first one. Yeah.
No, we good. We good, leadership. Much appreciated.
Good.
Yeah.
Okay.
Well, maybe I will just move on to taking questions now. But let me quickly acknowledge Brother Vuyo, the president, and of course MP for ATM, also in the space with us. I see journalists also here. Situ Motabi, good to see you, and others. Kim Hela, Ausumposi, and all the good people in the space. Thank you so much for being with us. Of course, with me here, my co-host, Dr. Deza. With us, the Public Protector of South Africa, Advocate Busisiwe Mkhwebane, as well as the People's Advocate, Dali Mpofu. All right, Mkebs, I see you have your hand up. You are back, my brother, and then we'll bring Alu after that.
Hey, Mr. T, how are you? Am I audible now?
You are my leader.
All right, sorry, man. Actually, the network is giving me problems. Earlier on, I wanted to comment, but right now I'll just have one or two questions, Mr. T. Thanks to People's Advocate. We really appreciate your work. We've seen what you do. From President Zuma to Advocate Mkhwebane and so forth. I think as South Africans, we are not angry enough, seeing our own, going through what they are going. And as black people, we are so quiet. We are not angry enough. It's very clear that you advocate and others, you are fighting a very brutal system. The system that is not for us as black and my majority. It's clear, and I ask myself why so many people are prepared to protect one man, why so many people are prepared to lose credibility, to lose everything. Like, I know advocates, my advocate, you don't want to go in this, but I had a question, that as a law expert, better than most of us here. Which law did the acting PP use to write that letter? I'm not talking about, I know there are so many things that you don't even want to get into that, but I'm worried. I'm just trying to find the law that she used to write the letter to our PP, because to me I was like confused. I thought maybe something like that can come from other institutions, but from the very same office, I was like very confused. I know nothing about law. I just use my only common sense. And also, I don't know if you can answer that, advocate, but if you can't, I understand. And also, advocate, we personally, I'm closely monitoring and watching the Section 194 in Parliament.
Mhm.
You know, as a member of I'm a good member of the ANC in good standing, and I'm so ashamed, I'm so embarrassed. The conduct of more especially of a chairperson. Uh, you know, it seems like there is an agenda. Everything is cooked there. You are just there, for a show. And I know you might not have, like, because it's still ongoing. You might not have, you might not comment much on it. But I'm seeing, like Mr. T said it earlier on, everyone, like, it's DA on the side, it's judges on the side over a woman, Mr. T. We've seen that from President Zuma, of which I think he has exposed, he has opened our eyes. I heard many people like saying, hey, Zuma says he's gonna talk. But personally, I feel like President Zuma is talking, he's showing us so many things. But if you're expecting him to speak, like he's always saying, no, he's not going to speak. He's going to show us. Today, we are having a case against a Billy Downer and that self-proclaimed a journalist, masquerades as a journalist, but a politician, something we've never seen before. So I'm saying those things, it's way of exposing the system, how brutal it is. It's ways of showing us that advocates and other people, what are they dealing with. But Mr. I'll just be short. It's just that of parliament inquiry. It's so embarrassing to watch such thing. It's so embarrassing, advocate. And also, in terms of law, I was so confused what was happening in that letter. I I can't mention judges and DA. DA are prepared to work with Cyril. They're prepared to say Cyril must expel everyone in his cabinet and him. So over one man, the Reserve Bank, like what's happening in this country? But anyway, let me just submarine. Thank you so much, Mr. T, with this space, and I hope we're not gonna get tired, because that's where we can engage and open other people's eyes, because we are in tatters. Thanks, Mr. T.
Thanks, my leader. Thank you so much for that. Yeah, this inquiry, it's not even an inquiry. Ke hang pal, and it's backfiring. It's backfiring. Advocate.
Yeah, well, a quick one. The Okay, I'm still going to avoid the question about the acting public protector, but on the second issue, yeah, I think that it's quite correct that we're not angry enough. But it's also related again to what I call our readiness to just swallow a narrative that is crafted for us. And that's the reason, really, that we're not angry enough. I mean, just imagine the narrative that gets created and pre-packaged for your own mind. So basically, you have, and I'm using these examples. Let's take the public protector and the narrator. If just imagine if the person who was being put up as a person who's hard on service delivery. If you can't deliver, you must get out and make sure that you meet your targets, and clean audits and all that. If it was, let's say, assume that person was the rater, And then the other one who's making us miserable, as I'm talking to you now, I've just had a load shedding. I'm sitting in the dark in my study. And so many people, all the misery that's brought by load shedding and all that. Assume that was being done by Busisiwe Mkhwebane. Now, the narrative that you would have would be the exact opposite. The one would be a hero, the other one would be a villain. But because of our historical situation, the one who achieves clean audits, who's meeting the targets, who's giving us the best delivery from that Office of the Public Protector, who works on weekends and night to make sure that we get value for our money, is the enemy. And then we get conditioned so that we must want her blood as well and to chop her head. And the one who's causing us so much economic misery is fine. Nobody even thinks about even asking them to account, let alone impeachment or dismissal or something so drastic. Yeah. And that's, for me, that's the tragedy, and that's where the real tragedy is. When you see our people falling for such cheap narratives, and vilifying their own, yeah, so that you can't even. But anyway, and that's where we are. So we need to develop a counter narrative, because, as Biko said, if you want to oppress people, you must uh, really oppress their mind, and the rest is just becomes very, very easy. So I don't know what we're going to have to do to make sure that our people are not so easily manipulated. That if somebody decides that Mr. T is a thief and writes about it even in a newspaper or on a radio, says so on a radio broadcast, then that's it. Then it's true. But when it's the shoes on the other foot, then all sorts of excuses are manufactured and there's a knee-jerk reaction against those who stand on the side of black people or the poor. And you, as somebody once said, you can never oppress people without their permission, or even without their participation and cooperation in that oppression. And I think for me, those are the bigger issues. Of course, we have to deal with all the cases that were mentioned, the Zuma case, this case, and various other cases. But the broader issue is to educate our people so that they can fight and reclaim their country and reclaim their minds, their own minds, and make up their own minds about who's good or who's bad without being conditioned to do so by the enemies of our people. Yeah. Thanks.
No, thank you very much, Advocate, for that lengthy submission and response. I'm going to go to Alu. I know that he has some burning questions there and probably want to engage the PP. So let me give Alu the opportunity.
No, thanks. Don't actually have burning questions. Just two quick questions. I think for the advocate, if he is generous enough to indulge me. The first one relates to the section 194, not the committee, but the actual provision in the constitution that allows the president to suspend a someone in the PP's position. Because I think the court, Western Cape High Court, confirmed now that in its reading the proceedings have started. So it says here that the president may suspend the person at any time after the proceedings started. So, Mr. Mpofu, does the president get one shot at this? Basically, what I'm asking, since he's now messed it up, he's made a he's made a mess of his opportunity. Does this mean that he does not have the power anymore to institute that or to give life to that provision, because it says at any time?
Yeah.
And I think the court also referred to the Section 90, which when the president is unable to perform his duties due to him being conflicted and not, he then may delegate the responsibility to his deputy president or to the minister. Now, is it open to him to say, okay, I'm conflicted now, I'm unable to perform this duty because obviously the court has told me so. What I'm going to do now is that I'm going to delegate this authority and then have someone else who is in my cabinet suspend the PP and I get what I want? Or is that something that would be I understand it would take it. I assume he would have to have a lot of guts to do that, but is it legally open for him to do that? And then the second quick one, just a comment on because I saw part of the case was you trying to get the court to develop our common law, especially when it comes to the rescission and applying the same principles that apply to appeals, which means that once someone appeals, it automatically suspends the order, and it does not look like the same is happening for rescissions where the two things are similar in their nature. And just a comment on that, because I see the court strike that down, if I read it correctly. Thank you.
Yeah. Okay. Quick one. On 194, which can go with Section 90. Remember, it is us who actually presented the Section 90 argument in the court. So, yeah, your first question. No, the president doesn't get a only one shot. Let's say if he was competent to suspend, but let's say he had missed one step or another, and the court said, no, you can't, you've missed the step, or you didn't do this, or you didn't give us a hearing, whatever, then he could rectify that. All public officials can do that. The problem that he has in this particular case is that he has literally been disqualified. That's what the people was reading from Section 157, is that this is bias of the disqualifying kind. So he can't, he, as Mr. Ramaphosa, cannot suspend the PP unless if the decision is reversed. He can, of course, delegate it to the next person, which, as I say, that's what we said should have happened. You're quite right. In real life, whether Mr. Mabuza or whoever there's a hierarchy of such delegations. I think it's the deputy president, and then it's any other cabinet minister or the speaker and whatever you. Yeah. That person, if they wanted to suspend, would have to start literally from scratch, as if nothing has happened, by asking the public protector to show cause why she should not be suspended, and so on and so on. So we would go back specifically to the 17th of March when the process started. And remember, we have not even gone into the issues of the representations that were made. So, because quite frankly, there's no reason to suspend the public protector. Because the only, the law of suspension is very clear. There must be, for example, a risk that you are going to interfere with the witnesses or that kind of thing. Yeah. And if there were such risks, this court would have said no. Even if this thing was unlawful, but you can't go back. That happened in the case of Ngasana, if you people might remember. There was where it was found that he had been unlawfully removed, but the court said, look, you can't take him back because there's already somebody there, or for whatever reasons. So it can be done, but this court didn't do that, and their omission in doing that speaks volumes here. The other issue is the third question. Sorry, I've just missed your last. The first question was 194. The third one was Section 90. And what was the third one?
Oh no, it was thank you for indulging me. It was the rescission common
All
law.
right. Yes. Okay. Yeah. No, that one is quite clear. The what we were saying. In fact, before I answer that question, let me go back to something I said earlier, where I'm saying that this DA move might actually end up backfiring, because we on our own, even though there are certain findings that were made against us, such as the one you're talking about, which I don't think was correctly made, speaking for myself, including this thing about whether the proceedings have started. I'm actually more confident about that argument than even the conflict of interest one. But nevertheless, the court found otherwise. But the point I'm making is that what the DA has done is, once they've taken the matter to the Constitutional Court, means that we also can cross appeal on the areas which we are not happy about, such as the development of the common law point that you are raising, as well as the interpretation of Section 194 3A. But coming specifically to your question, our argument was really quite simple, and I think it was dismissed on a technicality. So that's why I'm quite confident that if there was a cross appeal, it might succeed. And it was this, that the same effect of an appeal on a judgment or order should materialize in the case of a rescission. Now, that's not as revolutionary as it might sound, because until the current act, which was in 2013, this situation was governed by Rule 4911, which specifically said if you appeal or rescind the judgment, then it's suspended. So the two things used to be treated exactly in the same way. But when the current Superior Courts Act was put, it was only applying in the case of an appeal. So in effect, it was just saying, let's go back to the previous situation. Last point is, this judgment is very, very, very significant. Forget about the public protector for a minute, and the orders, and whether there's going to be an appeal and what have you. But that the judgment itself, in terms of it's very far-reaching. I don't think there's any judgment that has ever been so scathing and fatal, I think, to a president, a sitting president, to say, it's not a small thing to say a president acted out of improper motive or bias, or or was completely conflicted, and the conflict with their personal interest and so on. So I would think that if this judgment is left unchallenged by the other side, it should have quite far-reaching implications beyond this issue of the public protector. Thanks.
Thank you, Advocate. We have lost Lendes, Mr. T. So let me bring